All right. Good day, everyone. This is Criminal Law, CRJS312. I'm going to be lecturing today from our textbook. This is an earlier edition of our textbook, but it's the same title, Contemporary Criminal Law. The required textbook now is the fifth edition. My lectures come from the second edition because it's the book that I outlined. But I did cross-reference everything, so I'm pretty much talking about the legal principles, not necessarily going over the specific cases. So everything I'm telling you about, I've cross-referenced to make sure it was good and lines up, and it's relevant for today. I don't want to teach you guys any outdated law. Um, Once again, as I do before every lecture, let me let you in on a little secret. The book's website. See how close I can get. www.sagepub.com/Lippman, Lippman, CCL2e. What that means is Lippman Contemporary Criminal Law, second edition. You go to that website, you go to the student resources. You can go chapter by chapter, do flashcards to make sure you get flashcards to make sure you got the information. You can also, outside of flashcards, they do an outline for each chapter so you can know what the chapter talked about. Good way to prepare for class. And after you do all that and do your studying, or try to commit it to your memory banks and learn it, then you can test your knowledge by doing the quizzes that they have for each chapter. And I'll tell you now, that's where I get my questions from for all multiple choice tests, whether it be my midterm or my final. So I want the reason I'm telling you guys is, I know you're like, oh, why would Boyce do that? Like he's giving it away. I'm not giving anything away because surprisingly, people still miss multiple choice questions in my classes. It never fails. I just want you guys to do the work. If I tell you where to go to like further your knowledge, and I give you that roadmap, all my talking and lecturing, and I know I can be boring. Some people like it, some people don't. It just depends on your learning style. But at least it's not all for naught. It's not or all in vain. So I'm talking to you, telling you where to go. Then you get finished talking to me or listening to me talk. Then you can go online and actually do some work and study. And do these quizzes and master the information. I don't want to sit here and spoon feed you or be expected to give you everything. I want you to go out there um, and go to the book's website. It's a very good textbook, actually. When I first started, this is the textbook I got when I first started teaching. And I just never strayed away from it. I kept using it. As a matter of fact, I liked Professor or Mr. Lippman's book so much that even for the other class I taught, I wanted to make sure we got for like criminal procedure. I went and checked to see if Lippman wrote the criminal procedure textbook for Sage Pub, and guess what? He did. So I got that book too. I liked the way he organizes his textbooks. The way he kind of gives roadmaps before each chapter. At least he did in the second edition. I think that's valuable. So it kind of makes it easier to ingest. He makes it digestible, right? So it also makes it easier to teach and easier to outline. So I was able to outline, look at the cases, so I could teach it in my own words. But these are very good textbooks. So that's why I chose them. So I want you guys to go out there and kind of use the resources that have been given to you. So you can learn this stuff and commit it to not even. I don't want you to memorize it. I want you to learn it. And then when it comes time to be tested on it, because you've gone out there and done the extra work, you're going to be rewarded. You're going to see these quals. I've seen that question before. I know the answer to it. It's not that I'm giving you anything or making it easy, because it really wasn't easy. You had to go out there and do the practice questions to recognize that. But guess what? In doing the practice questions, you also learned. You learn what the right or the wrong answer was for it. So it's a way that I can teach you outside of lecturing. So that means even when you're doing it online quizzes, even when you're taking my test, you're still learning. So that's what it's all about. And that's just my teaching philosophy. Now, enough of that. Get off my soapbox. Let's talk about chapter 9. Last chapter we talked about justifications. We talked about the two. We mentioned in total or at the beginning, the two affirmative defenses. One being the two classifications of affirmative defenses. Affirmative defenses being the ones that, of course, the defendant has the burden of proving. In other words, the defendant is accused of something, and he says, "Hold on. I didn't, I did it, but I was either justified or I was excused." Then there's also other defenses like alibi, like it wasn't me, which is also affirmative. You might want to put forth evidence of that. But the two main categories are justifications, which we talked about in chapter 8. And then now we're going to talk about, in chapter 9, we're going to talk about excuses, which essentially says, yes, I did it, but I didn't have the mental capacity to understand what I was doing. So I did it, but I don't deserve to be punished for it. So let's talk about chapter 9. Let me get into this outline. All right, as an introduction, excuses provide a defense based on the fact that although a defendant committed a criminal act, he or she is not considered responsible. The defendant claims that although he or she broke the law, the act was wrong, he or she is not responsible and not morally blameworthy. So, of course, the first defense under the excuses umbrella is what we call the insanity defense. Common law initially did not consider a mental disturbance as relevant to an individual's being guilty or not. The common law slowly transitioned into recognizing mental disturbance as a defense. Defendants who rely on the insanity defense are typically required to provide notice to the prosecution. So, as a defense attorney, any affirmative defense, even if it is self-defense or defense of others, we have to give notice to the prosecutor that's going to be, we're going to use that as a defense. We just can't, jump into it the day before or right there at trial. So we have to give them notice. But definitely with the insanity defense, you definitely have to give them notice, because in that situation, you're talking with the insanity defense. Normally, your client or the defendant is going to have to be assessed. It is going to have to be some type of mental assessment, and there's going to probably be some type of trading of testimony from experts to determine, for one, whether or not the mental defect that this person suffers from is even going to allow them to be able to stand trial. Do they understand what's going on? Not only do they understand what they did, but do they understand what's going on right now? In other words, are they competent to stand trial? So that's going to happen. Then if they are competent, then of course they're going to have to be experts to come in, and they're probably going to be on both sides to determine, whether or not the insanity defense is going to be valid. So, okay. They are then subject to examination. I think I pretty much explained all this before. The defendants who are going to use the self-defense are typically have to provide notice to the prosecution. Then they are typically subject to examination by state-appointed mental health expert, and will usually hire one or more of their own experts. That's what I was talking about, trading of experts. These experts will interview the defendant and conduct various psychological tests. The prosecution and defense experts will then testify at trial, and additional testimony is typically offered on behalf of the defendant by people who are able to attest to his or her mental disturbance. The jury is then asked to return a verdict of guilty, not guilty, or not guilty by reason of insanity, or what we call the NGRI. Let's see here. In some jurisdictions, the jury considers the issue of insanity in a separate hearing in the event that the defendant is found guilty. So the defendant can be found factually guilty, but then there's a separate trial, what we call a bifurcated or split trial, two trials to determine not just competence, but because competence wouldn't be in trial without being competent. But they do a separate trial to kind of figure out whether or not the person is actually insane and may be excused from their conduct. A defendant found not guilty by reason of insanity in some states is subject to immediate committal to a mental institution until he or she is determined to be sane and no longer possesses a threat to society. In most states, a separate civil commitment hearing is conducted to determine whether the defendant poses a danger and should be interned at a mental institution. This period of institutionalization may last longer than a criminal sentence for the crime for which the defendant was convicted. So there are, that's why it's not a good idea to fake the insanity defense, because you could end up being a facility longer than you would have been in jail for the offense. Now, the book asks, why do we have an insanity defense? Free will. The defendant did not make a deliberate decision to violate the law. His or her criminal act resulted from a disability or lack of free will. Then it talks about, as a second reason, it says theories of punishment. A defendant who is unable to distinguish right from wrong or to control his or her conduct cannot be deterred by criminal punishment, and it would be cruel to seek retribution for acts that result from disability. 3. Humanitarianism. An individual found not guilty by reason of insanity may pose a continuing danger to society. He or she is best incapacitated and treated by doctors in a non-criminal rather than criminal environment. So, tests for insanity, and this is where we're going to spend the bulk of our conversation. So, different jurisdictions have different standards or tests to determine whether someone is insane. The fundamental difference among these tests is whether the emphasis is placed on the defendant's ability to know right from wrong, or whether the stress is placed on the defendant's ability to control his or her behavior. So there are two main tests. There's actually the two main tests, and then there's like what we call the product test, which is kind of a hybrid, and then but the two main schools of thought. The first one is right and wrong, what we call the right and wrong or Monotony test, and then the other is the irresistible impulse or inability to control one's actions test. So let's first start with the right and wrong test, or what we call the Monotony test. At the time of committing the act, the accused must have been suffering from such a defect of reason, from a disease of the mind, as a result of which the defendant did not know what he or she was doing, or the defendant did not know he or she was actually doing something that was wrong. So in other words, because of the mental defect, they did not know the difference between right or wrong. They didn't know what they were doing, and they didn't know what they were doing, whether what they were doing was right or wrong. So we call it the right or wrong test. Certain jurisdictions apply that test. They say, and then what they're saying is, based upon these tests, psychologists talk to this person and assess them. They're trying to determine whether or not when the person committed this act, did they know right from wrong? Did they know what they were doing? And and even if they did know what they were doing, did they appreciate whether it was right or wrong? In other words, does their mental health defect affect their ability to distinguish between right and wrong? So that's the first test. Of course, the mental disease or defect requirement is satisfied by organic or physical damage, psychological disorder, or intellectual deficiency that results in an individual's either not knowing what he was doing or not knowing he or she was doing wrong. Mentally ill. Having a disorder of thought or mood which significantly impairs judgment, behavior, capacity to recognize reality, or ability to cope with the ordinary demands of life. It does not include a mental state shown only by repeated unlawful or antisocial conduct. The most common mental disorders that result in insanity under the Monotony test are psychosis or neurosis. Psychosis, a psychological disorder that results in the inability to distinguish between reality and fantasy. Or neurosis is simply a compulsive drive to engage in certain behavior. So psychosis is when a person kind of doesn't know what's going on. You don't know what's reality and fantasy, and you're kind of acting in the fantasy world. So I would say psychosis is more along the lines of schizophrenia, where people hear people talking to them or hear voices, and the voices are telling them what to do. So they don't know whether the voices are real or whether they're fake. So that's a form of psychosis. Then neurosis is when there's some impulse or some compulsive drive to just do something without thinking about it. Mental conditions not considered. Psychopathic or personality disorders that lead individuals to engage in patterns of antisocial criminal conduct. So a sociopath is essentially someone that has social issues, or they essentially put themselves in a position mentally where they believe they're better than everyone else in society, and they don't have to follow the rules. Let me get a better definition. Let's go to the old Google to make sure I'm right. Um, Yeah, a person with a personality disorder manifesting itself in extreme antisocial attitudes and behavior, and a lack of a conscience. So there's a difference between a sociopath and a psychopath. A sociopath is someone that just isn't that has this social belief, and they're antisocial. They don't want to do what everybody else does. Um, so it's not necessarily based on psychology or any type of brain defect. It's more of a social, how they act socially. We did talk about the two types of mental disorders: psychosis and neurosis. Um, Mental conditions not and we talked about what's not considered. So sociopaths are generally or these people are generally aware of the difference between right and wrong, and believe that they are above the law and the rules that apply to other people. Being a sociopath is not a mental defect, um, at least under the Monotony rule. Courts differ on what it means for a defendant to know that his or her act was wrong. Some judges interpret know to require an understanding that the act is prohibited. Others demand a demonstration that the defendant fully comprehends that the reason the act is wrong is because of the resulting harm. Um, there's also an ongoing debate over whether a defendant must know that an act is a legal wrong, or whether the defendant must know that the act is a moral wrong. So the different jurisdictions that ask different questions. Um, the right and wrong test is clearly much too difficult to be easily applied by even the most educated and sophisticated juror. In the end, jurors tend to follow the common sense notion of whether the defendant was legally sane or insane. So there were some cases in there. I won't go through them too much because this is some rather dense material. So in the state v. Crenshaw, the defendant was honeymooning with his wife and suspected unfaithfulness. He beat and stabbed her to death and decapitated her. He then drove to a remote area and disposed of her body and cleaned the hotel room. The defendant claimed to be a member of a religious sect that required a man to kill a wife guilty of adultery. He claimed he believed that his act, although illegal, was morally justified. He argued that his act was lawful rather than moral. Under either a legal or moral wrongful test, the defendant was legally sane. Um, his effort to conceal the crime indicated that he was aware that killing his wife was contrary to society's morals as well as the law. Courts should not define wrongfulness, and jurors should be left to apply either a societal morality or legal wrongfulness approach. Then you have the case of Clark v. Arizona. The United States Supreme Court upheld the constitutionality of an Arizona statute that limited the insanity defense to individuals who did not know what they were doing was wrong. The statute did not include within the definition of insanity the other part of the Monotony test that takes in individuals who do not know the nature or the quality of the act. So just in discussing Well, let's go to the next test before I kind of wrap all of them together. But the McNaughton test, and the reason I like the second edition is it has these equations. Um, the McNaughton test, a right or wrong test, equals a defect of reason from a disease of the mind, a psychosis or neurosis, not sociopath, plus at the time of the act did not know, so there's a lack of knowledge. Two, the nature and the quality of the act that or that the act was right, whether the act was wrong or that the act was wrong. So they did not know that the nature or the quality and the quality of the act was wrong. So it's exactly what it says. It's a right and wrong, what we call the right and wrong test. The person's mental defect led them to a place where they just didn't know that what they even if they knew what they were doing, they didn't know that it was wrong to do so. Let me see. Okay, we'll skip that. All right, now the second test is the irresistible impulse test. So we have right and wrong, and then we have the irresistible impulse test. These are the two main, um, what we call the two main tests. And the other tests kind of bounce off or take ideas or become hybrids of these two tests. This is the second test, what we call the irresistible impulse test. It requires a jury to find a defendant not guilty by reason of insanity in the event the jurors find that the defendant possessed a mental disease that prevented him or her from curbing his or her criminal conduct. The McNaughton test is criticized for focusing on the mind and failing to consider emotions. An individual may be capable of distinguishing between right and wrong and still may be driven by emotions to steal or kill. A defendant may be found legally insane under this test, despite the fact that he or she is able to tell right from wrong. So it's not as much about whether they knew right from wrong in the irresistible impulse test. It's more about whether whatever happened to them led them to act impulsively. There's no requirement to act in an explosive or impulsive manner under the irresistible impulse test. And it may calculate, and a person may calculate, plan, and perfect their crime. Must consider whether the disease overcame his or her capacity to resist the impulse to kill, rape, maim, or commit another or any other crime. Irresistible impulse test. What is it? Pretty much at the time of the crime, was the defendant afflicted with the disease of the mind? If so, did the defendant know right from wrong with respect to the act charged? If not, the law excuses the defendant. So it does have some of the right and wrong in it when we apply the irresistible impulse test. So in other words, if the person didn't know right from wrong, we don't even go to any other questions that they're insane. Let's say if they did, if the defendant did have such knowledge, the law will still excuse the defendant if two conditions occur. One, if mental disease caused the defendant to so far lose the power to choose between right and wrong and to avoid doing the alleged act that the disease destroyed the defendant's free will. And then two, if the mental disease was the sole cause of the act. So the irresistible impulse test, and when we go through the what I call it, the flow chart kind of, or the analysis, we start off by asking right or wrong, whether or not they knew right or wrong. So it kind of is kind of a furtherance of the irresistible, the right and wrong test. So you ask yourself at the beginning, does the person know right from wrong in their actions? If they do not, then that now ends the assessment, and you say, well, if they didn't know right and wrong, then they're insane. If they did, then you go to another set of questions where you say, well, does the mental disease cause this person, essentially give them an irresistible impulse where at this point, even though they know right from wrong, they still couldn't control their actions? And then that's it in a nutshell. Several jurisdictions have abolished the irresistible impulse defense and converted to the strict McNaughton standard. Um, it is an affirmative defense. The burden of proof. The defendant has the burden of providing the defense of insanity by clear and convincing evidence, which is still well below, um, beyond a reasonable doubt, that the prosecutor has the burden of proving. Um, then next we have the third test, which is a little bit of a hybrid of the two, is the Durham product test. And doesn't necessarily mean Durham, North Carolina, just Durham. I think it comes from the case, the name of the case, the person's name in the case. Um, it was intended to simplify the determination of legal insanity by eliminating much of the confusing terminology. The product test was formulated by the New Hampshire Supreme Court in State v. Pike in 1869. The standard was not accepted or even considered by any other jurisdiction until it was adopted in 1954 by the United States Court of Appeals for D.C. The test provided that an accused is not criminally responsible if his unlawful act was the product of mental disease or defect. Uh, so essentially, it's kind of, it's not necessarily a hybrid. It just says if this person has a defect and whatever he did was a product of that defect, we're not even asking whether it's right or wrong or resistible impulse. Was his conduct the product of his mental ailment? Um, this permitted expert witnesses to provide a broad range of information concerning the defendant's mental health and simplified the task of the jury, which now was only required to determine whether the defendant acted as a result of that mental disease. Doesn't matter whether they knew right from wrong, or whether there was an irresistible impulse. So I'm sorry, there are actually three schools of thought. My apologies. Um, so jurors were no longer placed in a position of making difficult determination whether the defendant knew the difference between right or wrong or acted as a result of irresistible impulse. The only requirement was to evaluate whether the accused was suffering from a disease or defective mental condition at the time he or she committed the crime, and whether that criminal act was the product of such abnormality. So it simplified it for juries. So this test left the definition of mental disease or defect undefined. Um, so the D.C. Court of Appeals abandoned this experiment after 18 years after realizing that the product test had resulted in expert witnesses playing an overly important role at trial. So what that did was it gave the product test gave expert witnesses a lot of power. So essentially, it became, well, this person, that their activity or their actions were cause or were the product of their, or were not the product. So it kind of gave a lot of power to expert witnesses, which probably leaned towards the prosecution in most of those cases to say that it wasn't the product. So the product test equals, this is the equation: unlawful act plus was the act the product of a disease or defect. So it's just a simple question. Okay, this fourth one is the hybrid of irresistible impulse and McNaughton, or right and wrong. This is called the substantial capacity, or the American Law Institute test. So it's a modified version of the McNaughton right or wrong and irresistible impulse test. A person is not responsible for criminal conduct if at the time of such conduct, as a result of mental disease or defect, he lacks substantial capacity either to appreciate the criminality of his or her conduct or to conform his conduct to the requirements of the law. The terms mental disease or defect do not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. The important point is that the substantial capacity test significantly broadens the test for legal insanity and increases the number of defendants who may be judged to be legally insane. Appreciate. What does that mean? A defendant may lack a substantial capacity to appreciate rather than know the criminality of his or her conduct. So it's not about what he or she knows. It's about whether or not, even if they know it, whether or not they appreciate, or not. I don't say respect, but it's whether or not they appreciate the right and wrong of what they're doing. Um, Appreciate also means whether they appreciate the results or the harm that is caused as well. This is intended to highlight that a defendant may be declared legally insane and still know that an act is wrong because he or she still may not appreciate the full harm and impact of his or her criminal conduct. Substantial capacity. Um, the test requires that a defendant lacks substantial capacity to appreciate the criminality of the conduct or to conform his conduct to the requirements of the law. So there's kind of it's a lack of understanding or appreciation plus the inability to conform, which sounds a whole lot like the irresistible impulse. A test calling for total impairment is not workable because it limits the application of legal insanity to individuals suffering from a delusional psychosis or to individuals who have absolutely no capacity to conform their conduct to the requirements of law. Um, So, what's it mean to conform conduct to requirements of law? The American Law Institute standard does not use the word impulse in order to avoid the suggestion that individuals who are driven by emotions to break the law must act immediately and spontaneously and may not reflect and brood over the plan of their criminal conduct. Wrongfulness. Wrongfulness is an inability to appreciate that the community morally disapproves of the act and explains that in most cases, an individual will be unaware that such an act is also contrary to criminal law. In order to be considered legally insane, a defendant who believes that his or her criminal conduct is justified must possess an inability to appreciate that the community would view his or her act as immoral. In other words, the accused must believe that the community would endorse his or her murder or an individual who, in fact, is a messenger of Satan. And that was in quotes. The test also stresses that mental disease or defect does not include sociopaths or an abnormality that causes repeated criminal antisocial conduct. The ALI test, or the American Law Institute test, was abandoned by most jurisdictions after the Hinckley case. The Hinckley case was the case where the guy attempted to assassinate. He shot Ronald Reagan with a handgun, President Ronald Reagan, but of course Reagan lived. And Reagan was found, and Hinckley was found to be insane. So the substantial capacity test, mental equals mental health or defect plus substantial incapacity. I'm sorry. And then plus to improve to appreciate criminality or wrongfulness of an act or to conform conduct to the requirements of the law. So there are some cases. Gonna kind of slide through those. Burden of proof. The defendant possesses the initial burden of going forward in every state. So if you're going to bring forth an insanity defense, the defendant has the burden of putting it on the table. For one, they have to give notice to the prosecution. The defendant is presumed sane until some evidence is produced challenging this assumption. The burden varies and ranges from reasonable doubt to some evidence, slight evidence, a scintilla of evidence, preponderance of the evidence, or by clear and convincing evidence. It just depends on the jurisdiction. But whatever it is usually less than beyond a reasonable doubt. Because you can't do anything work. The highest standard in all of the highest burden of proof is beyond a reasonable doubt, and there's no mathematical burden of proof, nothing mathematically that would be more stringent than that anyway. The prosecution then possesses the burden of persuasion to establish sanity beyond a reasonable doubt. So once the prosecution brings the case, then the defendant has the affirmative defense. That means they have to bring up the fact that their client or the defendant is insane. So once they bring it up and give notice of it, then the burden shifts back to the prosecution to prove that the person is sane and knew what they were doing. But it's hard as a defendant, you can't bring that up and just leave it alone. You're gonna have to bring it up and produce evidence that the person is insane or is suffering from either the right and wrong test. They're insane under the right and wrong test, the irresistible impulse, or the Durham product test, or even the American Law Institute test. So either way it goes, you're gonna have the defendant is gonna have to produce evidence that their client is insane. Once they produce that evidence, then the burden shifts to the prosecution to prove that they actually are sane. So either way it goes, the defendant can't just bring up insanity and just leave it alone. They're gonna have to produce evidence, through testimony. They're gonna have to get the client's gonna have to be questioned and assessed by professionals, and there's gonna have to be experts that do this. So it just is what it is in mental in insanity cases. Um, so Okay, the prosecution then possesses the burden of persuasion to establish sanity. We talked about that. The defendant must meet this burden in order for the issue of insanity to be presented to the jury. So the defendant it goes first. They have to show that, hey, my client is insane based upon whatever the standard is in this jurisdiction. And then once they put forth that evidence, then the prosecutor now has to disprove it. They have to put on evidence to disprove it. The future of the insanity defense. Some states have abolished the insanity defense and instead permit defendants to introduce evidence of a mental disease or defect that resulted in a lack of criminal intent. So, and everything we've been talking about. Remember, we have the two main elements of a crime. You have the actus reus, or the act, and then you have the mens rea. Now, when we're talking about these affirmative defenses, at least I'm sorry, the justifications and excuses. Remember, we're not denying the act. We're not denying the actus reus. So to deny the actus reus is to say I wasn't there. I didn't do it anyway. Almost that would almost be like an alibi. Like, hey, not only I didn't shoot the gun, I didn't shoot the person, but in these affirmative defenses with justification and excuses, you're essentially saying yes, I did factually commit the act. You're just saying either I was justified in committing the act because of circumstances, like I was defending myself, or I lacked sanity to be able to commit it. So when we're talking about these excuses, particularly when it comes to insanity, we're talking about a lack of mens rea. We're never the actus reus is not even in question in these justifications and excuses, especially in these excuses. With excuses, really what comes into question is whether they're able to even develop or have the mindset to have a mens rea to commit the crime. So that's kind of what's in question. Um, there's some, of course, you're saying the person committed the act, but they were insane, so they're excused. There's some jurisdictions that say, well, rather than saying they were excused, how about you say they're just not able to have the mens rea because of their mental defect. So remember, to prove that a person is guilty of a crime, they must prove that they committed the act and they did it with the mental state that was required that would have required to be simultaneous with the act. So if they suffer from a mental impairment, the mental impairment might keep them from even being able to develop that mental state of that mens rea. So that's what that's saying. So states, a lot of jurisdictions are kind of leaning towards that. In such jurisdictions, evidence of state of mind is admissible to negate criminal intent, and the judge who finds that a defendant convicted of a crime suffers from a mental condition requiring treatment shall incarcerate the defendant in a facility where he or she will receive treatment. 13 states have adopted a verdict of guilty but mentally ill, or instead of not guilty by reason of insanity, they have what they call guilty but mentally ill. Jurors may select from among four verdicts: guilty, not guilty by reason of insanity, or guilty but mentally ill. The verdict of guilty but mentally ill applies where the jury determines beyond a reasonable doubt that a defendant was mentally ill but not legally insane at the time of his or her criminal conduct. The defendant receives a standard criminal sentence of confinement and is provided with psychiatric care while interned. The intent is to provide jurors with an alternative to the insanity defense that provides greater protection to the public. So let's see. Next, we have diminished capacity. Diminished capacity permits the admission of psychiatric testimony to establish that a defendant suffers from a mental disturbance that diminishes the defendant's capacity to form the required criminal intent. So there's a difference between insanity and maybe having being what they call it slow, or having developmental issues that may put you in a position where you can't really develop the mens rea. It's one thing about mens rea, whether it be purposeful or intentional, knowingly, recklessly, or negligently. It requires some level of mental capacity to be able to develop a mens rea. So with diminished capacity, essentially what they're saying is it's not necessarily saying my client's insane, but it's saying that my client suffers from a mental disturbance that diminishes the defendant's ability to form the required mental intent. It merely recognizes that an individual has the right to demonstrate that he or she is incapable of forming the intent required for the offense. This is a compromise between finding an individual either not guilty by reason of insanity or fully liable. Some states confine diminished capacity to intentional murder and provide that an accused may still be convicted of second-degree murder, which does not require premeditation. This defense has been rejected by some states that point out that psychiatric testimony is unreliable and too confusing for jurors, and that the medical model is contrary to the notion that individuals are responsible for their actions. The Model Penal Code provides that evidence that a defendant suffers from a mental disease or defect is admissible whenever it is relevant to prove that the defendant did or did not have a state of mind that is an element of the offense. The defendant may introduce psychiatric evidence to negate the required intent in a prosecution for any criminal offense in Model Penal Code standards. Now we'll move on to intoxication. So there are two types of intoxication. There's voluntary intoxication. That's when you get yourself drunk, you go out there and sit at the bar, and you toss back these beers or drinks until you're drunk, or you smoke weed, or you do any type of drug, and you do it yourself. It's voluntary. Voluntary intoxication was not recognized as a defense under common law, a defense for anything. In common law, the intoxicated individual shall have no privilege by his voluntary contracted madness, but shall have the same judgment as if he or she is in his right senses. Some jurisdictions actually still follow this common law rule, so it doesn't matter how drunk you are. If you got yourself that way, you're not excused from anything you do. At modern law, however, courts have recognized a distinction between offenses involving specific intent, for which voluntary intoxication is an excuse. So remember, voluntary intoxication is an excuse to specific intent crimes. Remember, we talked about a couple of specific intent crimes. Normally, your specific intent crimes is when the crime requires an intentional act plus an additional intent. So like burglary, the intentional breaking and entering of the dwelling place of another with the intent to commit a felony therein. So it's the initial intentional act coupled with an extra intent, or what we call a more specified intent to do something, like assault with intent to kill. So assault itself is a general intent crime. So it's the intentional inflicting injury upon unwanted or unlawful or unconsented contact with the person with intent to permanently injure or kill. So anytime when we talk about specific intent crimes, there's always that extra intent put on top of it. So that's how you recognize specific intent crimes. So with voluntary intoxication, is only a defense in specific intent crimes. So I had a trial one time where my client was accused of he was accused of malicious conduct by a prisoner, which was what we call a specific intent crime. And he was also accused of a general intent crime, which was assault on female, assault. My client was extremely drunk at the time, and he was essentially charged for spitting on officers because he was so drunk he was slurring at the mouth, and every time he spoke, spit came out. So what happened? We were in the middle of a trial, and the evidence came out that my client was extremely drunk, and we were able to get So during the middle of the trial, the DA saw what was going on. He saw that my client would the defense itself. I mean, he would be defended against his against this specific intent crime that he was charged with, but he would not be which was a felony. But he would not be able to use the defense in the general intent crime. So in the middle, in the general intent crime that he was charged with was actually a misdemeanor. So in the middle of the trial, the DA during the break after we put on our evidence, or were in the middle of putting on our evidence, offered us a deal to dismiss the felony and have my client plead guilty to essentially what he was guilty of. And wasn't going to be justified or excused from. So we were able to walk out of court with a misdemeanor conviction in that situation and not a felony. So that's an example of how voluntary intoxication is only a defense to what we call specific intent crimes. And I'll read it out to you. Courts have recognized a distinction between offenses involving specific intent, for which voluntary intoxication was an excuse, and offenses involving general intent, for which voluntary intoxication is not recognized as an excuse. An individual charged with a crime requiring specific intent was able to introduce evidence that the use of alcohol prevented him from forming the specific intent to assault an individual with intent to kill. The defendant would be held liable however, for simple assault. So literally, what happens in those cases where a person is charged with the specific intent crime and they're bringing up voluntary intoxication as a defense. Usually, what happens is with prosecutorial discretion, the prosecutors just reduce it down to something lesser that is general intent. Some type of lesser included offense is general intent, and it usually leads to some type of guilty plea, but guilty to a lesser charge. All right, let's move on. Involuntary intoxication. Involuntary intoxication is a defense to any and all criminal offenses in those instances that the defendant's state of mind satisfies the standard for insanity defense in that state. What that means is, now with involuntary intoxication, remember you're intoxicated but not at your own volition. So someone has spiked your punch or put something in your drink and it now causes you to go out of your mind. All that means is if you're involuntarily intoxicated at the time something happens, you're able to now use the involuntary intoxication as to prove that you were insane. So in other words, you apply whatever insanity or incapacity test applies in your jurisdiction. The Model Penal Code requires that the individual lacks substantial capacity to distinguish right from wrong, which essentially applies the Manhattan test. So because of involuntary intoxication, you fall within in the Manhattan jurisdiction. You couldn't tell right, you didn't know right from wrong or appreciate what was going on. Involuntary intoxication can occur in any of four ways. Duress. An individual is coerced in consuming an intoxicant. Mistake. An individual mistakenly consumes a narcotic rather than his or her prescribed medicine. Fraud. An individual consumes a narcotic as a result of a fraudulent misrepresentation of the nature of the substance. Medication. An individual has an extreme or unanticipated reaction to medication prescribed by a doctor. So you have duress, where essentially you're coerced or something is dropped in your drink as well. So a couple cases, not gonna go through those. Now the next excuse is age. So that means we've talked about insanity, diminished capacity. We've talked about voluntary intoxication and involuntary intoxication. Now we're going to talk about age. So in other words, the question is, can a child or someone below a certain age form the intent to commit a crime? Early common law did not recognize infancy as a defense to criminal prosecution. Youthful offenders, however, were typically pardoned. Common law developed into what we call the rule of sevens, and essentially, I'll explain the rule of sevens. What it means is children younger than 7 years old lack mental capacity. It means if you were younger than if you were younger than 7 years old, you cannot commit a crime. Even if you took the act, you were not able to commit the actus reus with the required mens rea because of your age. And it was an irrebuttable presumption. So what that meant was essentially any child less than 7 couldn't commit a crime. Then a child older than 7 and younger than 14, there was a presumption that they did not have the capacity to inform intent, but this presumption was rebuttable, meaning that the prosecution could overcome the presumption by evidence that the juvenile knew what he or she was doing. So you go from younger than 7 years of age where they cannot form intent to now between the ages of 7 and 8. I'm sorry, 7 and 14 or 13, where it's presumed that they cannot form the intent and can't be guilty of a crime, but that presumption is rebuttable. So it allowed if they were between the ages of 7 and 13, the prosecutor could put forth evidence to show that, hey, even though there's a presumption that this person can't form the intent and can't be guilty of a crime, we're allowed to put forth evidence to show that they did know what they were doing and they appreciated what was going on, and therefore they can be found guilty of a crime. So it was a rebuttable presumption. Then we get to children 14 and older possess the same criminal intent and capacity as adults. Juveniles capable of forming criminal intent may be prosecuted as adults rather than remain in the juvenile system. Then we have 2 modern jurisdictions. Age of capacity differs from state to state, but there is a conclusive presumption of incapacity for juveniles younger than that age. Other states provide that juveniles, regardless of age, may be treated as an adult. So it just depends on where you are. But for questions, for questions that may come up, we're in this class, we're going to apply that common law rule of sevens. So less than 7 can't form intent, can't be guilty of a crime. Between 7 and 13, they are presumed to not be able to commit a crime, but that presumption can be disproven. So it's what we call a rebuttable presumption. So the prosecutor can put forth evidence that this 13-year-old knew exactly what was going on and therefore should be found guilty and tried. And then you have 14 and up where they have the same capacity as adults and they can be charged with crimes and convicted of crimes. So that's the common law rule of sevens. 25 states continue to follow the rule of seven scheme while modifying the age categories. These states or either rule of seven or what they call tripartite or three-tier age system. These states provide that a presumption of incapacity may be overcome when a juvenile is demonstrated to have known the wrongfulness of his or her actions. Others specify age, typically 14, younger than which there is a conclusive presumption that a juvenile cannot form an age of intent. A third group of states, like North Carolina falls within these states, provides for exclusive jurisdiction by the juvenile court until a specified age. So if the person in juvenile court now used to be 16, but now it's 18, if a defendant is younger than that age, they're charged with crimes, but they're only charged with crimes in juvenile court. So they're punished in juvenile court and by juvenile standards, and it doesn't go to adult court at all. So there's no more presumption of whether this person can be charged, like a normal adult or charged with a crime. They're just punished. They're charged, tried, and punished in juvenile court. So that's how they handle things in North Carolina. These states typically provide that cases involving individuals between 16 and 18 charged with serious crimes may be transferred to adult court. So even in North Carolina, once they get a certain age, even if they're below that age, if they're close enough to the age or old enough, they can be tried as an adult, but they have to go through certain red tape to get to that. Okay, let me move. All right, couple cases. Now let's move on to duress, which is another affirmative defense or an excuse. Common law excused an individual from guilt who committed a crime to avoid a threat of imminent death or bodily harm. In other words, if someone committed a crime, but they committed the crime under threat, like either you rob this bank or I'll kill your family or I'll kill you, or you got a bomb strap, we got something strapped to your chest, and if you don't do what we say, we're going to blow it up. We're going to blow you up. That is duress. Individuals were obligated to desert the rebels as soon as the threat of harm was removed. Um, Elements of duress. Um, the defendant's actions are to be judged in accordance with a reasonable person standard. There must be a threat of death or serious bodily harm that causes an individual to commit a crime. Um, a threat directed against a member of a defendant's family or a third party may constitute duress. Psychological pressure or blackmail does not amount to a threat for purposes of duress. So it has to be, it's only threats of physical body harm to yourself or someone else or someone close to you. Um, Duress does not excuse the intentional taking of the life of another. Yeah, it does not excuse the intentional taking of the life of another. The law requires people to choose to resist rather than to kill an innocent person. The threat must be imminent, immediate, and imminent. A threat of future harm is considered to prevent an individual from making a reasoned choice whether to violate the law. Um, I'm sorry, a threat of future harm is not considered to prevent an individual from making a reasoned choice whether to violate the law, whether or not to violate the law. An individual must have exhausted all reasonable and available alternatives to violating the law. They must reasonably believe that the criminal act is the only means of preventing this imminent death or bodily harm. The defendant must not create or assist in creating the circumstances leading to the claim of duress. An individual must not intentionally or recklessly become involved in an enterprise in which it is foreseeable that he or she will be coerced into criminal activity. Married women were exempted from liability under common law. Of course, it's no longer the law. So, common law presumed that a woman who committed a crime in the presence of her husband acted under his direction and she was not responsible. So, of course, that goes back to the old school view of women as property almost. Um, Keep in mind that the individual exerting the coercion is liable as a principal in the crime, despite the fact that the perpetrator may be accused on the basis of duress, may be excused on the basis of duress. So, duress defense is allowed in cases involving escape from correctional institutions. Is allowed in cases involving escape from correctional institutions. State v. Unger. There's no alternative other than to escape or be killed or to suffer severe bodily harm. It is unrealistic to require that a prisoner wait to escape until the moment that he or she is being immediately pursued by armed inmates, and if it was sufficient that the defendant was threatened that he would be dead before the end of the evening. The duress equation that the book allows: reasonable belief of an imminent or immediate threat to another plus death or severe bodily harm against the defendant or close relative or family member or anyone else that threat causes the defendant, based upon a reasonable person standard, to commit a criminal act. The defendant and also the defendant must not have placed himself in the situation. The defendant and also is not the duress defense is not allowed where someone is killed or where the defendant kills someone. Okay, This is a case, United States v. Contento Pachon. The defendant challenged a judgment of the United States District Court. which convicted the defendant of unlawful possession with intent to distribute controlled substance. The defendant was convicted of unlawful possession with intent to distribute a controlled substance. The defendant appealed, arguing that the district court erred in excluding evidence of duress and necessity defenses. On appeal, the court reversed the decision of the district court. The court ruled that the defendant had presented sufficient evidence of duress to present a triable issue of fact. The court concluded that the defendant agreed to attempt to smuggle the cocaine into the United States in his body under a well-grounded fear of immediate harm to his family with no opportunity to escape, and that a triable issue existed as to whether the defendant took the opportunity to escape by submitting to authorities at the first reasonable opportunity. The court reversed the conviction of the defendant. The court ruled that the defendant had presented sufficient evidence of duress to present a triable issue of fact, and the district court erred in excluding such evidence. Next, we have mistake of law and mistake of fact. So, if you make a mistake or didn't know something was illegal, or, whether or not it's a defense. Mistake of law. The general rule is ignorance of the law. That means not knowing whether something is illegal or not is never an excuse, and so it's not going to be a defense. Several considerations. Knowledge. People are expected to know the law, even though we don't. The law is codified and put in books and made public, so that means you put on notice. Evidence. The defendants may falsely claim that they were unaware of the law. This claim would be difficult for prosecution to overcome. Public policy. The enforcement of law ensures social stability. Uniformity. Individuals should not be permitted to define for themselves the legal rules that govern society. Softening trend. Notice. Lambert v. California. The law requiring a felon to register with police within 5 days was unconstitutional because it violated the due process clause, because the law was unlikely to have come to his attention. Intent. U.S. v. Cheek. The vast number of tax statutes made it likely that the average citizen might innocently fail to remain informed of the provisions of the tax code. So those are certain cases where ignorance of the law has been where it's kind of softened, and they've allowed it in certain cases. Reliance. Cox v. Louisiana. The court reversed the conviction based on the defendant's reliance on police officers' instructions that they could legally picket at a location 101 feet from the courthouse steps. Model Penal Code recognizes an ignorance of the law defense when the defendant does not know the law and the law has not been published or made reasonably available to the public. Let's see. Now that's mistake of law. Now let's talk about mistake of fact. Mistake of fact constitutes a defense in those instances when the defendant's mistake results in a lack of criminal intent. Model Penal Code. Ignorance of or mistake is a defense when it negates the existence of a state of mind or mens rea that is essential to the commission of the offense. First, determine the intent required for the offense, and then second, compare this to the defendant's state of mind. Some courts require that the defendant's mistake must be objectively reasonable, meaning that the reasonable person would have made the same mistake. An individual may be mistaken, but nonetheless will be held criminally liable in the event that the facts as perceived by the defendant still comprise a crime. Example, a defendant may be charged with receiving stolen umbrellas and contend that he or she believed that the package contained stolen raincoats. So either way it goes, it was stolen. But if he believed he was receiving something that was legal but didn't realize it was illegal, then he may be excused. So mistake of law. In general, there's no excuse for mistake of law, not knowing the law. So the only exceptions are maybe cases involving notice, where there was no notice given of the law itself, or where there was a reliance on law enforcement or someone that knows better that told them that what they were doing was legal, but even though it wasn't. Then you have mistaken fact. Mistaken fact. Mistake is an excuse if it negates the required criminal intent. Then we have, I think last but not least, I think this is the last excuse. It's a slow chapter. Let's get through this thing. Good Lord. Okay, this is a long chapter. Trying to get us through this. I'm tired of talking about it. The next one is entrapment. Entrapment is important. A lot of times, I want to, even though I'm tired of talking. Entrapment is something I definitely have to explain because students get it wrong all the time. Entrapment is the conception and planning of an offense by an officer of the law and his procurement of its commission by one who would not have perpetrated it except for the trickery, persuasion, or fraud of the officer. The essence of is the government's inducement of an otherwise innocent individual to commit a crime. So you got an undercover officer walks up to an innocent person, walks across the street, and says, "Hey, would you carry this across the street for me?" Okay, carry it across the street. Then they immediately arrest him and say there are drugs in that suitcase. That's like, well, you told me to do it. So that's an example of entrapment. Um, this extends to the activities of undercover agents, confidential informants. So informants are also, even if they're not actually cops, informants end up being an extension of the government or law enforcement, so they count. And private citizens acting under the direction of law enforcement personnel. All that can be entrapment. All those people can be law enforcement for in determining entrapment. The defense may not be invoked to excuse a crime of severe violence. So it's only for regular crimes. It can never be, possession or something like that. You can't say you were entrapped into killing someone or beating someone up. You can't use entrapment as a defense in that. Common law did not recognize entrapment as a defense. Now let's talk about the law of entrapment. What entrapment is? First, you have the subjective test. Remember, we talked about subjective. Uh, it focuses on the defendant and asks whether the accused possessed the criminal intent or predisposition to commit the crime, or whether the government created the offense. But for the actions of the government, would the accused have even broken the law? Was the crime the product of the creativity or creative activity of the government, or the result of the defendant's own criminal design? Two steps. First, determine whether the government induced the crime. Two, determine whether the defendant possessed a predisposition or readiness to commit the crime with which he is charged. The government must direct its undercover agency against the unwary criminal rather than the unwary innocent. Then we have the objective test. This is the model penal code approach. It focuses on the conduct of the government rather than on the character of the defendant. So it's all about what the government's doing. Whether the police conduct revealed in the particular case falls below a standard to which common feelings respond for the proper use of government power. The test is whether the government, by offering inducements, is likely to attract those ready and willing to commit crimes should the occasion arise, or whether the government has relied on tactics and strategies that are likely to attract those who normally avoid crime and through self struggle resist ordinary temptations. So, in other words, entrapment is the government inducing an innocent person or a person that's not likely to commit a crime into committing a crime. That's all it means. You have two tests. The subjective test asks whether this person was likely to commit a crime anyway, and the objective test focuses on what the government or the law enforcement did to make this person commit the crime or induce them to commit the crime. So it asks whether the crime itself was really the idea of the defendant or whether it's the idea of the government. So that's what entrapment is. So don't mix entrapment up with anything else. Someone telling on themselves in jail, or or talking to someone in their jail cell is not entrapment. So I know we get that stuff all the time. It's like, no, entrapment is when a person's chilling, and the government comes to them and says, do this, and they say okay, and then the moment they do it, then the government says, you're under arrest for doing this. It's like, you just told me to do it. That's an example of entrapment. New defenses. A lot of this stuff isn't really recognized everywhere. You got abuse excuse, which is almost like what do you call it? Battered wife syndrome, where people are using that as an excuse. Because I've been beat so long, I reacted. And other excuses: postpartum psychosis, psychological defenses, post-traumatic stress disorder, stuff like that. So the book talks about that as well, but we're not going to go into all those. Not going to be relevant to our testing. So let's see. That is it for chapter 9. Thank God. That was a long chapter. There was a lot to talk about. How long? Oh, yeah, an hour and 9 minutes. We almost an hour and 10 minutes. So you guys be good. I'm tired of talking. I know you guys are tired of listening, so be good.